Mr. Motz, I believe you're up first.
Thank you very much, Chair, and thank you. Never called you Mr. Carey before, but in this sitting, probably I will. Thank you for bringing this forward and for advocating on behalf of victims in our justice system. And I will start my questions with you this morning. Can you take a couple minutes and tell us maybe a deeper dive into the inspiration behind this bill and provide some background? I know you talked about Ms. Freeman, but this has been on the books or in the works for some time. Can you give us some background as to how this came about?
Thank you very much for the question, Mr. Motz. It was a personal thing. My father actually knew Lisa's father. We attended the store that he worked at. Lisa came to me and explained her trauma and re-traumatization, because this bill really is a simple bill. It's for transparency, and really it's about the mental health of victims. When something like this happens, it's a forever trauma. And every time there's a change in sentencings or parole or anything to do with the offender, it just brings this up again and again and again. So I'd like to just ask you for a moment to imagine you think that the killer of your loved one is a 25-year, a life sentence with no eligibility of parole for 25 years, and then you just find out that after 20 years, he's given a day parole and certain abilities, and then he's going to be released within 10 kilometers of your sister. Imagine if you're in that community, what might be the likelihood if you're at a grocery store or just going out in the community and you run into this person that actually killed your father. When she talked to me about the trauma and the re-traumatization and the lack of information and the lack of transparency, I felt it was owed to her and other victims that we should do better. And there's a lot of things I could talk about with the parole system, how we could improve it. And I think if we went around the table, people would have suggestions. But this bill really is just a small little change, but it'll allow victims of crime to be better prepared for these changes that are occurring to the perpetrator of these horrific crimes so that they can deal with them better.
Thank you for that. Obviously, as that was the impetus behind doing this. You consulted victim services groups, I understand, and could you share with the committee the type of support that this legislation received from victim services organizations that you may have been in contact with?
Yes, and I think committee members might have received a letter from Victim Services Durham Region, and I've also heard from many families who've been victimized by some of the most horrific crimes out there. But maybe what I could do, Mr. Motz, is just read a little bit from that letter just into the record. I'm writing in behalf of Victim Services of Durham Region to voice support for Bill C-320, an act to amend the Corrections and Conditional Release Act. Our agency has worked extensively with survivors and witnesses of violent crime and their families, including those impacted by homicide. We have seen firsthand the indescribable effects of trauma and the triggering and re-traumatization of those impacted as they navigate years of involvement with the criminal justice system. At every intersection with the system, they are reminded of the violence experienced and the irreparable harm done, no matter how much time has passed. And I could read through the whole thing, but it's basically when accountability, victims should know. All changes to a sentence related to a loved one's death or their own victimization can re-traumatize. Conditional releases, pardons, transfers, and impact offenders, but they also impact their victims. I could read from stakeholders. There's a letter I have from Daniel Silcox, and I don't know if you remember this case, Mr. Motz, but his father, James Silcox, was the first victim of killer nurse Elizabeth Wetlaufer. She injected him with a lethal dose of insulin in August 12th, 2006. The news of that murder sent his family into extreme trauma and downward spiral. But the offender was was sentenced to 8 life sentences, 4 7-year sentences, and 2 4-year sentences, and was eventually sent to Grand Valley Institute in Kitchener-Waterloo. And he is a registered victim relative to the crime. In October 2018, it came to his attention that the offender had been moved, but his calls to victim services in Kingston were met with indifference, and I was informed that due to confidentiality reasons, her new location couldn't be disclosed. And again, I could read through the whole thing, but he said, basically, I strongly believe that we have a right to know exactly where our father's killer is located, her movements, and we certainly should not only have the knowledge, but also input into the parole proceedings when they take place. And he complained about extreme offender bias, and that's what I heard over and over and over and over again from victims' families.
Well, thank you very much. I do, my time is extremely limited. I just want to make a statement, and hopefully you can get that out in the response out a little bit further. But I couldn't agree with you more that more information is always better when it comes to helping people through trauma, and the disclosure to registered victims is currently, woefully insufficient. And hopefully you can weave some of that response into that through some of the other questions. And I think my time is up, Chair. Thank you.
Lots. Ms. O'Connell, please. Oh, sorry, Mr. Biddle. My apologies.
It's okay, Mr. Chair. Thank you so much, and thank you, Mr. Carey, for bringing forward this legislation. I think it coincidentally ties in well with what we've been discussing as a committee, given our previous study and hearing from victims and victims' friends of a notorious serial killer. It's good that someone's brought this forward and taken the initiative, and so thank you so much. And it's not often that we have unanimity on something, and it's good to see in second reading that we have that here. I guess just building on one of Mr. Mott's question with respect to people consulted on this bill, and you mentioned speaking with victims and victims' rights organizations. Did you meet with anyone else beyond that? Academics, parole board representatives, or former employees, or anything like that? And if so, if you could let us know about those stakeholder meetings.
I did meet with mostly law enforcement and more or less victims' families. And Mr. Biddle, I want to thank you for your comments, because very rarely do we get a bill in front of us that we do all agree to. One of the things when I was first researching the bill is what could I do, what could I put in to make a difference in the system that would be significant for victims' families. One of the challenges we have, and I had this conversation earlier, when you want to make a change, sometimes you want to make a big change. And it can be arguable. So when you talk to lawyers, I know you're a lawyer, but if you ask a lawyer 7 lawyers for opinions, you get 10 or 20 different opinions on it. So I really did try to narrowcast this bill, and through my discussions and conversations with people who were affected and also people in the field, the idea was to make a small change, and hopefully with a minority government, this is something that all of us can hang our hats on and say that we're making a very small change. It's just, I think it's 10 words that are added. It's not taking anything away, but it'll make a huge difference in victims' lives, how they work with the system. And I guess one of the things I'm hoping for as well with your questions today is perhaps this bill will trigger more conversations, because if I go around the table, there's probably some great ideas that we have right here on improvements that we could make for the system. And I think all of us have families, friends, and loved ones who've found themselves in this situation. And as Mr. Mott said, you'll never go wrong by being more transparent and giving more information to people.
I appreciate that, and I think that was one of the things we've heard from the previous study is the lack of information, or information at the last minute, was re-traumatizing and particularly difficult. There's very little that I think we can do as a society for individuals who've suffered some of the most heinous crimes, or their family members have been through the most heinous of crimes. But we can take whatever steps that we can, and if information is something that is should be easy to provide. Did you have the opportunity to meet with or speak with the federal ombudsperson for the victims of crime about your bill?
I did not.
Okay. When appearing before our committee last month, the federal ombudsperson for the victims of crime said victims need clear information that explains how they can register to be informed about an offender and their sentence, and how to provide input for consideration before decisions are made. I was wondering how you could speak to how C20 will provide greater clarity to victims about their crime and their role in the criminal justice system.
Thank you for the question, and I'm actually quite happy to hear that the Ombudsman said that, because I do believe from their standpoint there's a realization that more needs to be done. This bill, and if I can take the opportunity just to read from the start of it, it's not going to make a huge difference, but if I can read into the record, sorry, it will make a big difference, but it's not a lot. The summary states it. The enactment amends the Corrections and Conditional Release Act to provide that information that is disclosed to the victim of an offense regarding eligibility dates and review dates applicable to the offender in respect to temporary absences, releases, or parole must include an explanation of how the dates were determined. And in my opening, I mentioned the experience of Lisa Freeman, my constituent, and she basically said, how in heaven's name did they decide to allow this person to be released, but even be released into a neighborhood close to my sister? And as things progress, like victims' impact statements, things along these lines, if the victims have some of that information, it allows them to at least prepare mentally for the day when they may be confronting. And also with this bill, I think what's really important, it's about giving victims the choice, okay? Because some victims are different than other victims. Some victims want to know a lot of information. Others don't want, they just want to put it past them. So I think that this really carves out a very small change that's going to make a big difference. And I'm happy to see mostly, I guess, unanimous consent for it, and hopefully it moves forward. And like I said, if there's any other dialogue that can be stimulated by the bill, I'm really open to that as well. So thank you for that, Mr.
Thank
Biddle.
you so much.
Mr. Carey, Mr. Biddle, and we'll welcome Mr. Perron to the committee. And Mr. Perron, you're up for 6 minutes.
Thank you very much, Mr. Chair. Thank you for welcoming me, and thank you, Mr. Carey, for this important bill. I've been listening to you since the beginning, and I'm not an expert on the matter. I'm here replacing a colleague, so if I say things that you've heard before in other studies, you'll have to forgive me. I'm very interested in the trauma of victims, and in your previous answer, you mentioned that we need to give victims the choice whether they want the information. And I understand that you have studied this. Have there been any assessments? Is this positive for victims? So we're basing this on the choice of victims and victims' families on if they want the information or not.
Excellent question. I'm not aware that this has been studied in any detail. What I do know by talking to numerous victims and their families is that it's unique to every individual. When I said earlier on that it seems that the perpetrator's rights are put forward versus victims and victims' families' rights, what I've heard is from families that with this unbelievable trauma, they see the perpetrator getting assistance through the correctional system, but they don't get that. It's not necessarily something that they have access to as well. And I can't even imagine what these families go through, not just individually, but when one person dies in such a horrific way, it definitely affects the central family. But we've seen it where the whole neighborhood, we've seen the interviews where it's like, I knew this guy, really surprised, whatever's going on. It's a psychological hit to the entire community, and sometimes with some of these more horrific ones, the entire country. So everyone deals with these traumas in their own unique ways, and by allowing them to have a choice, when they're ready, it may be a year from now, it may be 15, 20 years from now. Lisa got more involved, it was 20 years. And in her mind, it was supposed to be a life sentence with no eligibility of parole for 25 years. And the fact that it happened earlier, she was taken by surprise, the trauma, the uncertainty of the system, and Mr. Biddle's comment about the ombudsman actually coming before you and realizing, there are things that we are aware of that we need to do. We're learning more and more. These things don't go away. These are life-changing events, and how each and every victim and their family adapts to that is something we have to be very cognizant of and respect, and allow them as much transparency as possible, and as much transparency as they're able to digest themselves at that time. So, Mr. Perron, you've brought up an extremely important issue, and as I said, with this bill, I think we've got good support around the table for it, but maybe it's going to bring up some other questions on how we can make improvements, and I thank you for your question.
Merci beaucoup, Monsieur Carey.
Thank you, Mr. Carey. Another question. In your bill, you will be forcing the authorities to give the information to victims, and we agree with this. Have you thought about a minimal timeline so that people or victims aren't hearing about this at the last minute or when it's already done? Because now, in the way that it's written, it may not be very clear. Is there a time frame where authorities will have to notify victims before notifying the perpetrator, for example, and changing the priority here and notifying the victim first, and who we take care of most? And we agree, we need to take care of the victims first.
And I agree with you 100%. We need to take care of the victims first. The challenge with this bill, when it started, it was a lot more encompassing, and then the decision had to be made, what did I think that we could all agree on? So, in a perfect world, in my viewpoint, we should give these victims the information ahead of time. And, my assumption as well is when you're dealing with a government service, that they're going to be reasonable, they're going to be timely in their disclosures, things like that. But even looking at a word like advanced or timely, if you're a lawyer, what does that mean? You know what I mean? I could say to one lawyer, what does timely mean? He might say within a day or two. Somebody, when I do talk to lawyers, they definitely say things like, well, it depends. So that argument really is beyond my scope. I'm a chiropractor by trade. I'm not a lawyer, but I could play one on TV, I suppose, with this new goatee. But the reality is, these are the larger conversations. And I know Lisa, who inspired me for this bill, what she's hopeful, if we can pass these small changes that'll make a big difference, it will also inspire us maybe to ask some more questions, simply like you said, because I think Canadians would see it as reasonable that there's advance notice or a certain amount of time that people would be able to be prepared in advance for some of this, especially if it's going to be so re-traumatizing.
Thank you, Mr. Perron, and welcome, Mr. Garrison. You're up for 6 minutes, please.
Thank you very much, Mr. Chair, and it's a pleasure to be back in public safety. Some of you may know I served here for, I think, 7 years and haven't been back for quite a while. I want to thank Mr. Carey for bringing forward this bill, but I do want to point out that he's been working on this bill quite a long time, and there's a few things that have happened in between. In particular, the Justice Committee, where I now sit, conducted a very large study on government's obligation to victims of crime, which was tabled in the House on December 22nd of 22 and was concurred in by the House in June of this last year. And that report has 13 recommendations about how to better serve victims, which were unanimously endorsed in committee and in the House of Commons. So some of those larger questions that you're talking about, I think are addressed in that report. And I'm sure that you've seen the report. As usual, our challenge is getting action on those recommendations. So I wonder if you have any comments on the issues that were addressed in that report on improving support to victims of crime.
Well, first of all, I'll correct you. I haven't seen that report, but I should have seen it. It'd be nice to see it, and maybe I'll talk to you afterwards about it. But you mentioned, getting action. And one of the things about this bill, Mr. Garrison, I think it's something that we can get action on. I think it's something that we can all agree on. As I said, I'm not a lawyer, but I do know that words have particular meanings, and the words that we have in this bill will give victims a little solace on ensuring that they do get information so they can actually prepare themselves, because it isn't something that's a stop-go thing. It continues for the victims and the victims' families. And if we can make this one small change, it would be greatly appreciated by the victims' communities.
I think you're quite right in identifying that while we may have differences on some larger issues, we do largely agree on what you're proposing in this bill, and it's a good idea. Recommendation 4 of the Improving Support for Victims of Crime report points out, though, that the way we operate with information to victims right now is still on request.
Yes.
And there's a recommendation 4 in the report that says that the key sections of the Canadian Victims' Bill of Rights should be amended so that information is automatically provided to victims and that they can opt out if they don't wish to receive information. And so what we heard from victims then was quite often people don't have a good idea of when to make requests or what requests they can make. And so the report recommends reversing that onus, so the system must notify victims. And if victims don't want to hear that information, they can then opt out. I wonder whether you took that into consideration when you were preparing this bill.
No, as you rightly pointed out, I've been working on this for quite some time, and it would have been before that report. But if you'll give me the opportunity to comment on that recommendation, I think that's an excellent recommendation. I think that the work that you did in that committee to do a reverse onus would be extremely well received in the victims and victims' rights community. One of the challenges, again, I'll go back to when I first met Lisa, victims don't know. Families don't know what's available out there. They don't know what to do. They don't know how to stick handle their way through the system. It's panic when they hear of these changes. So anything that would make it easier for information to be channeled towards victims and their families, I think, is an excellent recommendation. So you have my full support for that recommendation on that, Mr. Garrison.
Thank you, Mr. Carey. One of or I guess maybe there are two related issues that also came up in that study was the lack of resources for victim support organizations, and the fact that quite often, in fact, we depend on volunteers to provide support to victims, and a lack of training, a lack of training for people in the justice system on victims' rights. And so that's two things also I think that I probably have your agreement that we need to spend some more time making sure that victims aid organizations are properly resourced, and that the justice system has proper training in terms of victims' rights.
Absolutely. And victims have to be comfortable talking to different individuals. And you mentioned volunteers. And one of the things we do see is one of the ways to heal is sometimes family members who have faced these horrible situations themselves, who have been in extremely dark places. One of the ways for them to heal is to get involved and help others who they can relate that, oh my God, this is exactly what happened to me. And Mr. Garrison, what you mentioned is so important that we resource that not only with professional training, but the knowledge that victims and victims' families know that these services and these individuals are available. And doesn't always have to be a trained professional, somebody that, you know, can relate, that's gone through it. Sometimes it's the best person to talk to. So, again, thank you for that.
Thanks. And now we're moving into the second round, and we're starting off with Mr. Malelo.
Thank you, Mr. Chair, very much. Thank you, Mr. Carey, for being here, for moving forward on this important bill and this important initiative, and for all your comments so far here today. Much appreciated. I'll try my best not to be too repetitive. I think when we all find agreements, that sometimes is the case, but I appreciate your comments on the motivation that you had to bring this forward, specifically around the horrific crime that you spoke of. I'm curious, with the process as it is now, in your view, Mr. Carey, what would be the sort of the ongoing interaction as it exists between victims and their families and the parole board presently?
Thank you, Mr. Milo. And I guess my answer is going to be an opinion answer. And my opinion has been kind of shaped by listening to victims and their families. And unfortunately, I'm going to say it's contempt. And if you were listening to one of the letters that I actually read into the record, imagine your father is in a senior's residence, a place where you think that he's going to be safe and have the proper care for the rest of his life, and he's murdered. Having a 95-year-old mom in a senior's residence right now, God bless her, 95 years old, and she's sharp as a whip, a lot sharper than I am at 95. But when he tried to get information, he was stonewalled. In other words, the perpetrator's rights trumped his right to know. And I don't think it can be overstated that when somebody goes through this type of trauma, what maybe our bureaucracy sees as a small things, like why would you need to know, they're still behind bars type of thing. But in Lisa's case, if somebody's on day parole in an area where a family member is, I can't even imagine coming face to face with somebody walking out that you know murdered your father. So my perception is we need to do much better. And what's really, I think, great is the work of this committee, and Mr. Garrison mentioned, we're actually taking a look at this and seeing what changes we can make. And what I'd like to see, and what I think victims would like to start seeing, is a step-by-step recognition of what they're going through, what mental health challenges they're having. You know, when you're looking at a victim and a perpetrator, that sharing of information, you know, you can't have one without the other. And in order for that person to heal, the least we can do is give them the information that they need to make themselves be prepared for the things that they're going through.
Thank you very much. And you just mentioned it again, but as I understand, registered victims under the Corrections and Conditional Release Act do have access to some information. You just touched on it, but I'm wondering if you can go into more detail about why that information that they have access to presently isn't sufficient, and highlight how your bill will address that.
Yeah, and I think if you read it, it says they have a right to certain information, okay? And it's arguable, and that's one of the things why we didn't get into a lot of details in this bill, because we can argue back and forth what is reasonable information. But from a victim's standpoint, certain information that we as the government decide is important for them to have may not be what they, all-inclusive of what they need to know. And the idea with this bill is to give them a little bit more of that information, to be as transparent as we possibly can, to allow that transfer between victim and perpetrator so that, you know, they can learn from it, they can understand it, and as was brought up earlier, victims, they didn't choose this. They were thrust into it. They don't know what the system's all about. And if they need certain information in order for them to heal, to function, to remain employed, to remain in a family situation, a community situation, as a reasonable participant in society, it's the least we can do.
Thank you, Mr. Chair. Thank you, Mr. Carey, for being here as one of my colleagues in Durham Region, for sure. I wanted to continue on the questioning that Mr. Garrison actually brought up in terms of the idea behind automatic reporting. You said you fully support that. I do too. The lack of resources, ensuring that there's proper training. These are things that we heard in our previous study as well, in terms of making sure that there's trauma-informed individuals to kind of walk victims and their families through this process. There's even suggestions through the process of S211, and I had a constituent that was really involved in that process for publication bans and victims of sexual violence, and the need for, or even the suggestion of maybe even having legal representation for victims. Mr. Biddle spoke about the ombudsperson for the victims of crime, and one of the big things that were brought up were all of these things require funding and to be adequately funded. Do you support implementing these measures and making sure that they can actually be implemented through funding?
As far as the funding question is concerned, you know, right now, I think we would need to study that a little bit more. I know I've spoken to municipal officials, police officers on the ground, and depending on who you talk to, sometimes there's a feeling that if you reallocate, so if you put money here versus here, you actually will get different savings. If you get proactive, you can do that. So anytime that you get into an expansion of services, of course, there's going to be some resources that need to be put out. That goes beyond the scope of this bill. And I'm happy to sit down, Jennifer, with you anytime if you want to actually discuss some of it overall, how we would improve it.
Thanks.
But
Sorry,
it is kind of a difficult one to come up with right
For
off the
sure.
spot.
And I'd be happy to hear, because you know how this works and limited on
Yeah, I
time.
do.
If you have ideas, you said, you know, reallocate. If you have ideas, I'd love to hear them. But the Commissioner Kelly spoke about at this committee about the notification to victims, and I don't have the numbers in front of me, but she quoted the numbers. And so if we go to automatic reporting, which again, I actually agree with, it's just going to require resources. So just last week, you and all of your Conservative colleagues voted against $43.5 million to justice, which would actually include funding for the victims' ombudsperson and victim supports. You also voted against $290 million to Correctional Services Canada. So I guess my questions are around, we all support doing more. I fully support your bill, and I think it's honorable how you've represented your constituent in telling her story here. But I think what also matters is that if we're going to advocate for these change, that we also support the actual implementation of them. And that requires resources, whether it's reallocation or not. But cutting funding from a resource that the ombudsperson for victims of crime has already said is underfunded, I wonder how we can sit here today and say we support victims of crime, we want to expand their services, we want to expand trauma-informed training, we want to provide resources to help them navigate the legal system, and then vote against the resources to actually implement it. So I'm just curious if perhaps maybe next time there's an opportunity to support actually funding the services that we want to expand, that you can do so as honorably that you have in representing your constituent here today.
Well, thank you for your comment, Ms. O'Connor. And like I said, when you're looking at the entire justice system, I don't want to get too partisan about what we're talking about here today, but there are different approaches. And when you're funding a justice system, sometimes making decision A can affect decision B as far as criteria for parole, things along those lines, release into the community. And perhaps some of it wouldn't really cost a lot of money at all. When you talked about the Ombudsman Kelly talking about notification of victims, well, as we know, victims do get notified of different things. It's called, an envelope and a stamp. And how much information we put in that's one of the things I'm trying to address here with this bill.
No, thank you, sir. Just limited on time. How much would then
Point of order.
How much would it
Point of order.
cost?
Just a couple of weeks ago, Mr. O'Connell pointed out that the witness has as much time as the questionnaire. I don't think he's had as much time as her in asking the question. Can I get that clarified, please? She did point that out just a couple weeks ago. He should have equal time.
Okay, let's continue.
On that point of order?
Continue with who?
And
The witness?
We're actually
or
over
the
time,
question?
Ms. O'Connell. We're over time by about 25 seconds.
I just wanted to know what he thought it would cost.
You're out of time.
Okay.
Mr. Perron, for 2.5 minutes, please.
Merci beaucoup, Monsieur.
Thank you very much, Mr. Chair. We'll go back to the heart of the bill because that's what we have to do today. Mr. Carey, in your bill, you're asking for information to be given to families, but it doesn't specify what information. And I know you explained that it needs to be simple so that we can get consensus. But what would be the information and the justifications that you would like to see given to families?
What I'll do is
De quoi on aurait besoin?
What would they need? And I'll ask another question because I don't have a lot of time. The other element of my question is, in the bill, it mentions that for public safety, they could have perhaps certain information that might not be given elsewise. Would the victim be able to receive minimum information that there is a release, for example?
Yes, and what the information when it's released, it's at the request of the victim. So the victim has the choice. And to be 100% clear here, I'm going to read what line I'm adding. So basically, it is and an explanation of how those dates have been determined. Okay, so they're already going to be given information, and it kind of goes to Ms. O'Connell's question. We're already sending them a letter. We're putting a stamp on it. We're giving it to them. And if we're sending out this chunk of information, we're just adding a little bit more to it. And what would be determined in future committees, maybe we'd give more information.
Je m'excuse, je ne vais pas vous couper, là, mais...
I apologize for interrupting you. I only have 30 seconds, but I have a concern. I'm worried that we give an explanation, well, these are the dates that we had available for the transfer, or, explanations that don't give a lot of information and won't make them feel better. Is that not a concern that you share?
No, I don't. I'm actually quite certain that by making these small changes, by giving more information, more transparency, it'll give more solace to the families. This bill was not designed to address all the problems with the parole system, correction system. It was just one little step in the right direction. And to be clear, I have not had anyone say that they're against this bill. So, yeah, we could do more, and maybe that's a conversation we can have. But with this bill, I did kind of narrow cast it in a way that I felt that we could, around the table, all get behind.
Mr. Garrison for 2.5 minutes, please.
Thank you very much, Mr. Chair. As everyone's aware, I'm substituting for Peter Julian today, and he has a notice of motion he wanted me to place before the committee. So I think I'm going to do that right now, given the vagaries of time in committees. So Mr. Julian would like to give notice that he plans to move the following motion: that the Standing Committee on Public Safety and National Security hold a 2-hour meeting immediately after the winter break to study the possible impact of the Conservative Party of Canada's proposed motions and votes on December 7th, 2023, to cut each of the following supplementary estimates B, items of a total of $659,805,933 related to public safety. Canadian Border Services Agency cuts proposed of $23,051,792. Canadian Security Intelligence Service cuts proposed of $32,964,572. Correctional Service of Canada cuts proposed of $290,588,112. Court Administration Services cuts proposed of $22,743,433. Department of Public Safety and Emergency Preparedness cuts proposed of $176,059,072, and the Royal Canadian Mounted Police cuts proposed of $114,398,952. And so I'll send that off, and the people were receiving that through the normal committee channels. I felt at this time was a good time to do that because Ms. O'Connell has raised the important question that no matter what changes that we might make in favor of providing victims with more support and more information in law, that we have to actually carry that through with the resources that are needed to follow up on that. So I don't actually have a question at this point for Mr. Carey. I do thank him for the work he's done on this bill.
Thank you, Mr. Garrison. And just inform the committee we're getting down in time, so I'm going to move to 4 minutes each for the last two on the second round. So, Mr. Shipley, you're up, please.
Thank you, Chair. And I also will be planning to give notice of motion. But just before I do that, I'd like to just do a little preamble on it. And that is that we know that the carbon tax is driving up the cost of everything. But something that is overlooked is how this tax impacts the budgets of policing services. And I think that's important to discuss that here in public safety across this country, particularly in rural and remote areas where regularly driving long distances is required. For example, a large provincial police service with every 1 cent increase costs that police service an extra $250,000 annually on their police budget. The City of Peterborough recently had to increase their budget 11% due to many things, including the rising cost of fuel. Brandon, Manitoba last year, the Brandon Police Service had a deficit of $174,000, and the biggest contributor was the increased cost of fuel. Therefore, we must support our hardworking law enforcement officers across the country and call on the Liberal government to cancel the carbon tax. So my notice of motion will be, given that the Liberal government's costly carbon tax is driving up the cost of everything, including the cost of fuel, which negatively impacts the budgets of policing services across Canada, that the Chair report to the that the Committee report to the House that the Committee call on the government to immediately cancel the carbon tax. And I put that on motion, please. Chair, that's our notice of motion.
2.5 minutes.
Did you have any questions? I'll cede that back to you, Dan. Mr. Lloyd has it.
Okay. Go ahead, Mr. Lloyd.
Thank you, and thank you, Colin, Mr. Carey, for being here today. And, you know, it's important for me to be part of this bill because, you know, I had a tragic case happen in my area back in 2010 the McCann family, an elderly couple that were murdered on a road trip, and their bodies have never been found, but their killer is currently in prison and will be eligible for parole, if not already eligible for parole very soon. And it's critically important that we have legislation to ensure that, at the very least, that families and the victims' families get the transparency that they deserve, so that we can avoid any additional emotional trauma that, in our previous study on security reclassifications that we're in the process of completing, has been so clear when we have, friends of the victims, lawyers who represent the families of the victims come forth to committee and tell us about the severe impact. And so I'm hoping as well, based on Mr. Garrison's testimony, it seems that the Victims' Bill of Rights has this language in there that's clear, that it's on the request of the victim. And I note that in your bill, or your amendments, that it doesn't really deal with that. It just deals with amending part of it, that the information must be provided. What would be your thoughts about perhaps amending Section 26(1) to make it so that, unless otherwise requested by registered victims, that there is proactive disclosure from the parole boards and Correctional Services Canada to provide this information?
All right. Thank you, Mr. Lloyd. I would be in favor of that. I think anytime we can give more information, more transparency is a good thing. Until you're a victim of something like this, you don't even understand. You can't even relate to what needs to go through, the hoops you need to jump through. So anything we can do, first of all, to listen to victims, as you said, they've come before you. And as Mr. Garrison did say, it's like action. We've got a great report coming out of the committee, but has the government done anything about it yet? I guess not. But I'm hopeful today this is just one little step that all of us can move forward and make a difference in victims and victims' families' lives. So anything in that regard I'd be supportive of.
Thank you, Mr. Carey. And final questions, Mr. McKinnon, welcome back. Great to see you here. Go ahead.
Thank you, Mr.
4
Chair.
minutes.
And it's good to be back. I don't have a notice of motion, and I feel bad about that. But I would remark on the climate change aspect that the whole point of the carbon tax is to not pay it. So that over time we change our behavior so that we pay less and less, or we burn less and less carbon dioxide and so forth. And I should point out that we are at this point on track to meet or exceed our 2030 projections, in large measure because of programs such as carbon tax. Going on, though, I'll go back to Dr. Carey. So when this bill is said and done, and we've accomplished what you set out to do, firstly, I agree with your concern about trying to take too big a bite out of things. I've found with private members' bills that if you can keep it short and sweet and to the point, you're more likely to succeed. Whereas if you try and solve the whole world, there's too many things to go wrong and things fall apart pretty quick. So I respect that you made this very short and sweet. But once this is said and done, where do you see the next steps? What would be the next low-hanging fruit that you would see that we should take on in regard to victims' rights, and also giving deference to Mr. Garrison's comments about the report from Justice? So.
Thank you very much, Mr. McKinnon. It's good to sit around a table with you again, and I always appreciate your input. As you said, there's work that has been done, and I think what's key is we don't reinvent the wheel. If we actually take a look at what's been done and set timelines, and whatever we do it with the thought of victims in the back of our mind. Because what I've learned through this process is an unimaginable amount of trauma and permanent life changes that occurs when somebody is presented with this to deal with in their life. I don't know the background of everybody around the table, but I do know enough victims and their families to know that they're hurting. And they also have an amazing ability to reach out to others who are suffering the same way and to allow them a voice at committees like this to be able to discuss what the legislation on that they have to deal with means for them. Everything from stick handling, the bureaucracy, to dealing with the mental health issues that they have, their children, their families, their extended communities. Whatever we do moving forward, if we keep the victim at the back of our mind, and that is the person we're responsible for more than anybody else, I think we'll do good work.
33 seconds left, so we'll leave it there, and hopefully we can move on to clause by clause.
Mr. Carey, thank you for being here today. And committee, we're going to take a 5-minute pause here till we get set up for clause by clause.